Well, hello everybody, and happy Thursday. Happy first day of winter. I am Maya Engel, live in our digital studios here at Up North Live News, joined once again by Mary Ann Wehr. She is an estate planning attorney for Great Lakes Center for Estate Planning. So, Mary Ann, thanks so much for being here for, gosh, we're already on our sixth segment of Ask the Attorney. It is flying by.
It is flying by. It's hard to believe.
I know, right?
Yeah. Yeah.
So last time we talked, it was 2 weeks ago, we talked a lot about the probate process. So today we are going to kind of bounce off of that, continue that conversation, correct?
That's right. We're going to talk about tools and strategies for avoiding probate, actually. Yep. So, as always, I'm really happy to be here. I look forward to these nights. But we talked about the process, and we actually had a person on that night send her personal story that showed that sometimes things can get kind of hosed up in probate. They were nearly 4 years in and really no end in sight. So I promised as a follow-up as a discussion of strategies, right, that will help a family avoid the probate process if they so desire. And really, when you work with a lawyer, you'll decide whether or not you feel like you need to avoid probate. You'll understand it much better after working with a lawyer. But this is kind of a high level, as always, informational type of event, live stream. So, yeah.
And before we continue that conversation, I do want to remind our viewers watching at home that if you have any questions for Mary Ann at all, you can leave a comment on whatever platform you are watching on, and we will try to get to as many as we can. But going back to what you were saying, Mary Ann, so you said that today we're going to be talking about strategies to help families avoid the probate process. Are there multiple different strategies?
There are multiple different strategies, and I believe that the best strategy will be identified between you and your attorney. It's an attorney that will take the time to get to know you, get to know your objectives, get to know your assets, what you want for your family, what you want after you've passed away. And a good estate planning attorney will ask all about your assets and give guidance based upon your assets, your wishes, and the complexity that you may wish to navigate. So
is this process time consuming?
it can be. It can be. It does take some time. It takes some time to get to know your lawyer, clarify some questions. Sometimes there's questions that come up that cause you to think a little bit more and want to take a little bit of a break and talk about between you and your spouse. Like, who would you want to be the person who takes care of your estate in the end? It's not always an easy question. But when you put into perspective the time that you will invest into a thoughtful, mindful estate plan, you are just really giving your loved ones a sound plan. Peace. You can have peace of mind that you're saving them possibly, probably not 4 years, but possibly a long period of time not being in probate. And then, the cost of probate vary depending on the complexities. So it gets very expensive when it goes on for a long period of time or there's lawsuits. So you can feel confident after you've made a nice estate plan that your family is taken care of. I think that's what most of us are concerned with.
Sure. So it seems like a good plan will not only save a lot of money, but it can also save your family from the difficulties that you spoke of a little more last week. So can you start by talking about some of the different strategies?
Absolutely. And so the strategies for avoiding probate may, as I've said, may be different for each family. It's going to depend upon your family dynamics and then what you have. So what your assets are, I kind of call that stuff, like your investment properties, your home, your whatever personal property you might have, your retirement accounts. That's kind of, to me, your stuff. And so it depends upon what your assets are, because some of them are more complex than others. Some of them will drive a strategy a little bit different than others will. But then the second key question is how you want those assets to be used after your death, who you might want them to be to pass to, how you may want to pass them. And one strategy for your assets to pass to your heirs is through beneficiary designations. So anything that has a beneficiary designation will avoid the probate process and go straight to the beneficiary. So a good example of that is a life insurance policy has a beneficiary of who you want the, I think they're called proceeds, but the end of life proceeds to go to, and you identify that in your policy. And so really and you can do that with bank accounts. You can have a transfer on death beneficiary. You can do that with your house. We've talked about the Ladybird deed. That's actually similar to a transfer on death beneficiary. You can do that with your bank account or your investment accounts and retirement accounts. So almost everything you actually can identify a beneficiary for, and those properties would avoid probate. It may not, so this process or this method may not completely avoid probate because you have personal property, actually, your couches, your furniture, those types of things that do have to be accounted for, that there's no way to assign a beneficiary to. But it is a method. It will simplify anyway the probate process.
Mm-hmm. So that is just one method. You said there are multiple. So can you tell us about another strategy?
Sure. There is another strategy, and that's to create something that's called a revocable living trust. I think sometimes we lawyers like things that just sound crazy, right? Like, now let me tell you what that is, right? But it sounds confusing. But think of a trust as a box, or I like to think of it as like a little red wagon. In fact, I have a little red wagon behind me on the shelf that I use for my examples, right?
Convenient.
And that's the wagon like you had in your childhood. You put all your important things in it, and then you brought it around with you wherever you were going. And so during your life, the trust, either the box or the red wagon, holds all of your stuff. And as you progress in life, you keep putting more things into it. And sometimes you take things out, but it's all yours to do what you want to do with. So it follows you everywhere. Your trust follows you everywhere. It's your stuff. You can use it. You can sell it. You can give it away. You can let others use it. You completely control it. So it's your property inside a trust versus just, if you think about trying to carry multiple things without your wagon, things are going to drop off and fall, hit the ground, be forgotten. And those are the items that when you die, your family's going to have to go and pick up. I think I told you early on about a colleague of mine whose wife's father died, and they didn't know where all of his stuff was. He didn't have a trust. He wasn't all set up. They had to go searching for everything. And then they thought they had everything, and then they identified that he had a lockbox in some bank. He didn't know what bank, so they were in a small enough town where they were able to check all the banks. They found the lockbox, and in the lockbox were 752 paper IBM shares. So that's worth quite a bit of money. Luckily, they found it, but that would be something I would say that fell outside of the father-in-law's wagon.
Right.
So the trust really is trying to keep everything together.
Mm-hmm.
So it's a good thing. And anything that is in your trust at the time of your death, whether it's there during your life or if it's there as a beneficiary, will completely avoid probate. So using a trust, you actually, if you get everything inside that box, you do not have to go through the probate process. There is a trust administration process, but it's private. It's not in a courtroom. It's, quite a bit simpler. There's some formalities to it, but certainly quite a bit simpler.
Mm-hmm. So then why would someone need an attorney to place all of their things in the box or the little red wagon?
Yeah, it sounds like I can put my stuff in
Right.
my box, right? And I've got my box together. What an attorney does, what a lawyer will do, is draft a trust agreement that brings your objectives for that stuff kind of it to life. I like to call it your rule book. It's your rule book, and it's personally designed by you for your assets and for your family circumstances. It gives the rules of who is in charge of your stuff after you die, who gets your stuff, how they get it, and then the second piece of it. So that's a legal document that is drawn up, and the second piece of it is to put your stuff actually into the wagon or the box. There's various forms that need to be filled out. So a simple example is that life insurance beneficiary form. And you could have then the trust as the beneficiary to the life insurance. And then a more difficult example is placing your home into the trust. It takes a property deed, or if you want to put it in your trust as a beneficiary, there's a property deed, the ladybird deed we've spoken of. But those are documents that are that must be drafted by a lawyer. It's really the practice of law. So I just wouldn't, I wouldn't trust myself to do it alone without the help of a lawyer. And it is the practice of law, and it's all your stuff after all.
Right. Want to make sure it's taken care of properly.
Exactly. Yeah, you don't want it to just be floating out there. Right.
Right.
The one thing I would say is if there's property, so had the that family not found the 752 shares of IBM stock,
Mhm.
at a certain point after his death, and the bank would have located it, that would, it's called a cheat. It would go to the state, and it would go to the unclaimed property division of the state. And then I think there's a period of time that if it's not claimed from there, it actually goes into the state's bank account. So
Okay.
there's, you really want to keep track of your stuff. So you're giving it to who you want. But
Right.
yeah.
So let's say if I can name beneficiaries, then why don't I just name people and not the revocable living trust as a beneficiary? It seems like that would be pretty straightforward.
Yeah, it is. And it is straightforward. However, what just naming beneficiaries doesn't account for is life's unpredictability. Beneficiaries face expected challenges like financial difficulties, health issues, or legal problems that could affect their ability to manage their inheritance. If they had a lawsuit against them, they have somebody out there waiting, basically waiting for money. So you could your money could end up passing to your beneficiary and then right to their creditor. Those types of things can happen. And relationships evolve over time. You know, beneficiaries may go through a divorce, family conflict, or other changes that could impact their eligibility to receive and handle the assets responsibly. And face it, not everyone is financially responsible. I think one day I am, one day I'm not, but I think not everyone is financially responsible. And if they lack money management skills, they could potentially squander and misuse the inheritance. So these are all unintended consequences of just simply naming a beneficiary. The other thing is people, as you know, their lives change and things occur. Sometimes people develop addictions or dependencies, and where actually giving them an inheritance straight out may be the worst thing you could do, where you may wish to have your inheritance help them, but not provide them something for their vice. And so the key difference between just naming beneficiaries and using a trust agreement is no one can predict the future. No one knows what might happen in another person's life or in their own life through their entire longevity. So a trust agreement can be designed to proactively manage money for an individual that you have no reason to believe what's going to happen to them, but it can cover those types of contingencies that they're built into the trust. So you could have language in the trust that says if one of my beneficiaries is experiencing an addiction, then please place the money in another trust and allow him access to it in a defined way. Um, and these are just, examples, but another example is, a person who's too young, a person who is a minor. You want your children to have your money. Your child may be 10 or 12 or even 14, but they're not old enough under the state law to receive the financial benefits that's coming to them as a beneficiary. So that money will go into a special conservatorship account. So they can't, maybe they can use it. I shouldn't say they can't use it, but through special, forces kind of. But what will happen is the moment they turn 18, on their 18th birthday, all that money, whatever was set aside for them, is given to them. And when I think of myself or my son, or if I were thinking of a person in the role of inheriting from their parents. So if you're inheriting from your parents, they're gone. So already you have challenges in your life. If someone gave you $100,000 when you're 18 years old, that could disincentivize you from going to school. You could think, I've made it. I don't have to do anything. And it could be harmful. So using a trust to plan for those contingencies is always a good idea.
Sure. So it does sound like a trust can help a family meet even unknown circumstances and still meet objectives.
That's right. It certainly does. And another great example is we never know what our health, the health of one of our heirs is going to be at the time of our death. We just don't know that. We don't know. There's several things we don't know. We don't know when we're going to die. We don't know how much stuff is going to be in our wagon when we die. And we don't know the health of the heir, the person that's going to take. So an example that happens, sometimes a person in their 50s or their 60s, something happens to them and they are they go on Medicaid and maybe even into a nursing home because they've been in a car accident, they've been something bad has happened in their life. So they're in a nursing home, but now their 85-year-old mother dies and everything that's coming to them comes directly to them. And what would happen is they would immediately be disqualified from their Medicaid. That is their lifeline. And instead of that, in all of my trusts, I say, if one of these beneficiaries is receiving these needs-based benefits, life-sustaining benefits, then I create another avenue for them to be able to receive the money for themselves to enhance their life. But they don't get it outright. And that's something that I just heard the other day of it was on one of the listservs that I'm on, and it was my 63-year-old client's mother just died, and my client's is in a nursing home. This is not good, because she's going to be disqualified. So my point is that a trust is a document that really plans for contingencies, is attempting to be proactive and kind of meet the beneficiary where they are at the time of the person who set up the trust at the time of their death. And that is probably one of the biggest benefits of a trust, aside from the fact that a trust will avoid probate.
Mm-hmm.
So
there's certainly a lot to think about here.
There is. And it's just essential to consider these factors. In many cases, a complement to a beneficiary designation is a well thought out estate plan. Some things may still be a beneficiary designation for, really well thought out reasons, but it may include, as we've talked before, an estate plan may include a will, a trust, and other legal documents to ensure that your wishes are carried out effectively. And I think the key is in the best interest of your loved ones, because let's face it, we're gone, but we don't want to burden our loved ones with the act of kind of winding down our estate. So it is imperative to consult a skilled attorney who is able to provide guidance tailored to your specific situation. So, this is a plug for all the estate planning attorneys out there. My personal opinion is there's not enough of us. So, but do consult a lawyer who's skilled in the area.
So just to clarify, someone does need to go to an attorney for an estate plan.
They do. So estate planning under the laws of Michigan is considered the practice of law. So drafting an estate plan, working with a lawyer, it's considered the practice of law. So it's not a job for someone who's not a lawyer. And and sometimes we see out there people that are not lawyers offering estate planning services. And the reality of that is it's considered practicing law without a license. And the real difference is people can learn about this, but they're not lawyers. They don't think like lawyers. They're not looking at all the wide variety of the laws that intersect. They may be going through I don't know what they do, but lawyers like me and other estate planning lawyers out there are held to a very high ethical standard by the State Bar of Michigan. We are subject to malpractice, and we must follow the State Bar rules, or we're subject to discipline as well. So if we're not doing a good job, we're not doing the right thing, there is an agency or a governing body that is overseeing us. But if somebody is practicing law without a license, they don't have quite the reach to correct that situation. So I really suggest you go to a reputable attorney. And if you see someone, somebody offers you an estate plan and you're ask a lot, are they an attorney? Are they working with an attorney? Where does the attorney come in? Because it's not just, this is, as I've been trying to explain, this is not cookie cutter. This is individualized planning. Just this week, I'm applying IRS code, I'm applying property code, I'm applying Social Security Administration regulations on top of trust code and others. So it is not I said IRS. It is not to be looked at lightly.
Mm-hmm. And I think this would be a good time to mention, obviously, Mary Ann, you are an estate planning attorney. So if anyone watching does want to get hold of you, I left a comment in comments below that has her website and her phone number. So at any point, if anyone needs to get in touch with her, you have that resource in the comments. But going back to our conversation, Mary Ann, so if I have a trust drafted by a lawyer, will I avoid probate and protect my beneficiaries?
So that's a good question, right? There's many factors that go into that. So I can't give you a hard yes. I can give you it depends. But there's a lot of factors to consider with that question. Really, some of the onus is on you. Make sure that you and your lawyer have taken the time to get to know one another, and your lawyer understands your assets and your wishes. And they have to understand your beneficiaries. So if you hide the fact that you have a child that concerns you because you think they're drinking a little more than they should, don't hide that from your lawyer, because your lawyer could talk to you about various strategies for getting money to that person. Or you might just say, no, it'll be fine. But at any rate, you really need to talk about very personal things with your lawyer. And a trust, not every lawyer is created equally either. Everyone, there are trusts that are poorly drafted. So I would look for an estate planning lawyer that specializes in the area. And just remember that, if a trust is outdated, it will not meet your objectives. If it's poorly drafted, it may not meet your objectives. And you have no way of really knowing if it's poorly drafted, except for to ask the lawyer about their qualifications. Just trying to say that all trusts are not created equal. They're not plug and play. Yours wouldn't look like mine. Mine wouldn't look like my next door neighbor's. There's going to be common language in it, but there's going to be very intricate, specialty, personalized. And the other thing is, I recommend going to a lawyer who understands that the trust document is a rule book for your life, and that tells people how you want your assets handled. If it's not well written, or it doesn't account for the changes in your life or changes in the law. There's recently been big changes in the tax area for retirement plans. A trust may not work as intended if it isn't maintained. I guess I would just say, imagine building a house with outdated and confusing blueprints, and blueprints that follow old building codes. You're not going to get the expected result. So that really, a trust should avoid probate, but there's factors that go into it.
Mhm. Anything else you want to say about that?
Yeah. So I would say be cautious when you engage an attorney to draft an estate plan that includes a trust, especially. Talk to them about how you're going to fund, and we're going to talk about funding in January, but if they will do the funding for you. And again, funding just means moving your stuff into your wagon, but there are legal hoops to jump through in many of those cases. Some of it's just busy work. Some of it is finding the right beneficiary form, filling it out, signing it, and sending it back to the company. But it still is time, it's a time crunch for people. And it's confusing. So ask what kind of assistance that your lawyer is going to give you in that. And because it's critical, and we'll learn in January, if you don't do it, the document will do nothing for you. So you will spend a lot of money for a document not funded that really won't do anything for you. In fact, it is so important that starting in 2024, I do flat fee pricing. I'm adding funding to my packages. It will be included in the picture. But again, I'm looking forward to talking with our Oppenheimer financial advisor in January, and just getting everybody on the same page of understanding, when you get an estate plan, there are other steps to kind of activate it and make it work well.
Sure. Well, Mary Ann, we are running out of time. So before we go, is there anything else that you want to say about this topic?
Where does the time go?
I know, right? Every week.
I know, every week it's like, oh my gosh. Well, in ways, I've said it today, and I've said it before, but make sure that the trust is maintained and kept up to date. Life changes, so should your trust. If you don't review it regularly, it might not reflect your current wishes. Family circumstances change too. People that you have in key roles may no longer be interested in filling those key roles. So family dynamics can be complex. So do everything that you can do to keep it current, keep communication flowing within your family, so there's not big surprises, and know that you're in charge of your decisions, and place people in the roles that they fit. So that's what I would say, and use an estate planning attorney. One of us that are out there would love to help you out.
So before we go, Mary Ann, we do have a couple more minutes. So really quick, Denise just asked, will you be discussing an irrevocable trust in the future?
I certainly can. I started with the revocable trust because it's more common, but I can talk about an irrevocable trust. In fact, some of those tools that we use within a revocable trust for beneficiaries are irrevocable trusts, right? So, and there can be standalone irrevocable trusts. And once you've put something in an irrevocable trust, you basically don't own it anymore. So but there's reasons for using it. Sometimes Medicaid planning, sometimes tax planning. So I can certainly put that on the list. I won't be speaking about it in January, but maybe we can pull it in February.
Great. Well, thanks, Denise, for asking that question. And Thank you, folks, for joining us for our 6th segment of Ask the Attorney. Just a reminder, if you do have any questions for Mary Ann that you want to have her answer at any point, you can always email the newsroom. That is just newsroom@upnorthlive.com. Just ask your question and we will try to get to it next time. So we will be meeting again for our 7th segment 2 weeks from today. That'll be the new year, January 4th.
It'll be January 4th. The topic will be funding the trust, and I'll have a guest on again.
Awesome. Well, Mary Ann, thanks so much again for being here and for talking about such an important topic. As always, it is very appreciated, and we will see you in a couple weeks.
Okay, sounds great. Bye-bye now.
Bye, everyone.
Merry Christmas, everyone.
Yes, happy holidays.
Yeah.